Hello, everybody. Let's get started. On behalf of Simon Rice and myself, I would like to welcome you all to the second Australian Equality and Law Forum, this year hosted by Sydney Law School. We have 3 sessions for you today. Simon Rice will be moderating the first session and I'll return for the second one, and we'll be together in the third one. So I will hand over to Simon to get us started. Welcome.
Thank you, Belinda, and welcome everybody. I'm speaking to you from the lands of the Gadigal, Wongal and Camagal, on which university sits. It's only very recently that this university has started to come to terms with its occupation of Aboriginal owned land. In many ways, I think the very presence of the university on a hill overlooking the Sydney urban sprawl across Aboriginal land is emblematic of issues of inequality in contemporary Australia, inequality in education, employment, health services, more generally, I think, inequality in the opportunity to thrive and do well and be happy. On behalf of us all, I acknowledge that wherever we are in Australia, we are on occupied, unceded Aboriginal and Torres Strait Islander land, and I offer my respects to elders on all lands. We're here today to talk about and reflect on issues of equality, and I suppose by implication inequality. Wouldn't it be nice if we could just talk about equality without thinking that we're driven to do so because of inequality? We have focused on 2 contemporary issues of inequality, race, or areas of inequality, race and disability. The way things will unfold today is that the first session, the next hour and 15 minutes, we'll be looking at questions of race, or questions arising from race. And the second session this morning, after a short break, we'll be looking at questions arising from disability. And then the third session, we'll bring the 2 together and reflect on what advocacy around issues of equality and race and disability learn from each other, how they inform each other. I will chair this morning's session, Belinda will chair the second session, and our colleague Danny Sellermeyer will chair the third. We're in webinar function, which means as participants, you don't have access to chat, but you do have access to the Q&A. So while you're hearing the speakers, please record your questions in the Q&A. I see the Q&A and your questions are then, we can respond to those through the speakers. So whatever you're thinking as they talk, type it into the Q&A and I will get that as a feed, which will then inform the discussion we have. I'll invite you again during the session to keep the Q&A coming. Oh, sorry, the last thing I need to mention is that we have closed caption available. If you want to use closed captioning, then our events manager, Simran, is going to post in the chat instructions for you to engage the closed captions. I'm going to introduce the first of our speakers, Fiona Ellison, and then after Fiona, I'll introduce Paul, and then after Fiona and Paul have spoken, I'll be conversing with them and using your Q&A questions to maintain the discussion. I think I've checked off on all the administration, so I think we're ready to go. I'll introduce first Fiona. Dr. Fiona Ellison. I first met Fiona when she was at Redfern Legal Centre some time ago, but since then Fiona's done a lot. So Dr. Fiona Ellison is a research fellow at the Jumbunna Institute for Indigenous Education and Research at the University of Technology in Sydney. And she's a research consultant with Justice Reinvest New South Wales and chair of Justice Reinvestment Network Australia. At Jumbunna, Fiona is senior researcher for a First Nations Access to Justice project aimed at improving First Nations civil family law access to justice. Previously at the Justice and Social Inclusion Unit at the Cairns Institute at James Cook, Fiona was Senior Researcher for an Australian Research Council Indigenous Legal Needs Project, the first comprehensive national exploration of the civil and family law needs of Aboriginal and Torres Strait Islander people. And what you've just heard gives you a flavour of Fiona's focus, which she brought together in her PhD, which she'll be speaking to now, about access to justice and racial discrimination. Fiona.
Thank you, Simon, and thanks for having me. I'd just like to begin also by acknowledging the custodians of the country that I'm calling into the meeting today, and that's the Wujibwa people. I'm on Bundjalung country, and pay my respects to their elders, past, present, and emerging. So I'm going to share a PowerPoint with you. Yeah, just begin by saying, as Simon said, I've got a little bit of a history in this area. I had been working as a lawyer on Indigenous communities in the Territory and saw quite a lot of discrimination coming up for Aboriginal people up there, and then moved across to the Human Rights Commission to conciliate complaints, and didn't see a lot of complaints coming through from Indigenous people. And then became a researcher and started looking at civil and family law access to justice issues for Indigenous people. We spent about 5 years travelling to 40 communities nationally, identifying what sort of non-criminal legal issues were coming up for Indigenous people. Discrimination, and in particular race discrimination, and quite direct instances of race discrimination, were priority issues, or they were frequent issues that came up. And what we found is that people were generally not taking any sort of formal action in response to them. That project was quite focused on more traditional views of access to justice, so it was initiated by legal services, and we were really interested in whether they were accessing legal help for these issues. And we're now doing a different kind of project, which is turning access to justice on its head, and still focused on discrimination and other civil law issues, but thinking through how Indigenous people themselves define justice outcomes and the best ways to achieve those outcomes. So the work that I did in my thesis was doing a bit of a deeper dive into this issue of access to justice in relation to race discrimination. So I'm just going to start with a bit of history. In the mid-20th century, or post-World War II really, there was a big push for protection of human rights, including in the area of racial equality. And we had all sorts of instruments being developed, such as the International Convention on the Elimination of Racial Discrimination. We had domestic legislation in the US and the UK. And we also had race discrimination legislation introduced in Australia beginning in '66 in South Australia, and then we had the Federal Act in '75 and so on. And so alongside the introduction of legislation, there was a big surge in activism. So you have the anti-apartheid movements, civil rights movements in the US and Australia, and some of the key events that you're probably familiar with in Australia, and there was some focus on First Nations peoples here in Australia in that movement, include the referendum for constitutional change, so to include Aboriginal people in the Constitution, the tent embassy that was erected on the lawns of Parliament House in '72, and the Freedom Ride in New South Wales in '65. And so what you had is a coming together of this activism and the introduction of legislation, because some activists, including Aboriginal activists, pushed for introduction of race discrimination provisions in Australia. But we can also see is there was tension within the movement around what the objectives should be and how to attain them. So was it actually a valid objective to be pushing for introduction of race discrimination law? And it's interesting just to have a bit of a look at that, because it introduces some critical perspectives on equality from an Indigenous perspective. So on the one hand, in the movement, we have a focus on civil or human rights. So Aboriginal people wanting equal rights, right to vote, right to enjoy the same wages, right to travel wherever they wanted, and wanting to use mainstream systems, including the law. So you have Aboriginal activists engaging with litigation, referencing international human rights law, and calling for this domestic legislation, as I said. So Charlie Perkins, for instance, who led the ride, called for introduction of race discrimination law so it could protect Aboriginal people specifically, But interestingly, or importantly, that needed to be done alongside constructive and imaginative thinking from Aboriginal people themselves. And the freedom ride is a really good example of this type of method with these types of aims. There was confrontational protest by both Indigenous and non-Indigenous students. It was focused on segregation and civil rights, not so much on Indigenous rights, and it didn't really focus so much on the high levels of social exclusion that were out in the communities that they visited. And that materialised as, high levels of material disadvantage and disenfranchisement. So this kind of introduces this concept of formal equality, which is that everyone should be treated the same, which leads to the equal or same outcomes for everyone, and everyone has the same rights and entitlements. On the other hand, some activists, so I'm just trying to, can you see the gallery view on my screen? Do I need to move that so you can see the slides? Or can you just see the slides? No. Okay.
That's fine.
That's fine. All right. So in terms of substantive equality, some of the activists, both here and in the US, were saying that equal treatment or formal equality wasn't really sufficient. So we needed different treatment to respond to the particular circumstances or the disadvantage of different groups to ensure that you could truly get equitable outcomes. An example of this is affirmative action programs. So in a US context, those that were critical of civil rights legislation were saying that it's all very well and good desegregating lunch counters and buses, but what is the legislation able to do about addressing the economic status of disadvantaged people, housing issues, employment issues, and the institutionalised racism that they faced? And in Australia, we had criticisms of the 1967 referendum. Yes, it introduced a level of formal equality, but it didn't really change much substantively in terms of equality for Indigenous people. The other side of this was some really more outspoken activism, Indigenous activism that was about Indigenous rights. So they wanted to prioritise Indigenous rights based on prior occupation of the land. And these were rights to land and rights to culture as examples. They weren't actually owed the same as other people. Indigenous people were owed something different. And so they rejected equality as equated to assimilation and negating Indigenous rights. And this is just a quote from Kath Walker, who's saying Australians must understand that what is good for them does not necessarily follow as being good for Black Australians. The other thing was the method that they focused on, which was to be wholly Indigenous-led direct action, including to overthrow mainstream systems altogether, which were considered at best useless and at worst racially oppressive. So the tent embassy is a really good example of this. This emerged as a protest against the way the government had been handling Indigenous land rights, and it was very focused on those rights and on sovereignty. And you've got the Aboriginal flag flying at the embassy with Paul Coe saying, this was a significant step towards establishment of a Black nation. This quote from Roberta Sykes referred to the tent embassy as more productive than 20 years of legal attack. We need more embassies. We need more direct confrontation. So what happened was the activism actually did contribute to enactment of the legislation in Australia, because it revealed this racism that government then had to provide some response to, including because they were concerned about international criticism. And so you can see in the second reading speeches and other material that sits around the introduction of the legislation that government was actually quite committed to doing something through the legislation for Indigenous people in particular. So this is a quote here from Lionel Murphy. In introducing the legislation, he recognised the level of racism that First Nations peoples had experienced, and he speaks of the violent dispossession, destruction of their social fabric, and legal, social and economic discrimination. So it's pretty broad-ranging racism. In the end, we ended up with some legislation that was really much more focused on those formal levels of equality, rather than making any sort of broad sweeping changes. In pushing for the legislation, First Nations activists also, though, raised some concerns. So we had this legislation introduced in '66 in South Australia. Moriarty was an activist at the time who was a founding member of the Advancement League in South Australia, and just said, look, the legislation really hadn't been much good to us at all because of the way it was written and the way it had been implemented. This legislation was actually there had to be a prosecution initiated by the Attorney General after approaching police with a complaint, so it didn't work very well for Indigenous people. And then the second quote here is from another activist, Briscoe, who said, look, you know, basically we've got this pretty effective resistance movement in Indigenous communities, and what we're trying to do is impose on top of that legislation, a mainstream legislative structure that is alien to Indigenous people, and they're not going to have much respect for it. So these concerns really related to lack of First Nations input into the design and implementation of legislation, and that we also, noting that we also need to retain or build on Indigenous-led responses to racism too. What I also did in the work that I've done recently is just, I went back in time to look at racism in the mid-60s, looking at the Freedom Ride, and then I jumped ahead to now and spent quite a bit of time speaking to people out in community and also stakeholder organisations, particularly Indigenous stakeholder organisations, to ask them where we were up to now in terms of discrimination. So it's still, basically what people said is that it's still a major problem. What was also pointed out is that First Nations experiences of discrimination or racial inequality are different, and they're certainly at higher levels. So whilst one would think that, you know, given that we've had legislation introduced, yes, we have had some increase in terms of levels of formal equality, but Aboriginal and Torres Strait Islander people I spoke to said they were still experiencing really overt discrimination, particularly in public spaces. The other thing that came out really strongly was because we've had the laws in place for a while now, we've got a lot of covert discrimination, which still has substantial impacts. And this was spoken about in terms of more substantive or systemic inequality. So there was a lot of comment on institutional forms of racism as the most problematic form of racism for First Nations peoples. And this involved interaction with government and with government systems, with interventions in child protection and justice spaces highlighted, and failure to provide for basic needs on an equitable basis. So there's a quote here from a woman in Melbourne who basically was saying that, you know, back in the Freedom Ride days, Indigenous people weren't actually allowed to live in the towns that they were placed nearby in reserves and missions. Nowadays, it's not quite so blatant, but in terms of how Department of Housing is implementing their policies, they're still keeping Indigenous people in certain parts of town. So there's still segregation going on. There's also discussion of disenfranchisement. So I had looked at the Freedom Ride was reenacted in 2015, and there was some discussion at that point in time of about the fact that, you know, formal equality had been increased to a degree, but there's still this level of invisibility of Indigenous people. So this is a quote from Auntie May and Maureen, who said, "No one tells us anything. We don't control our own destiny. Things happen to us and not for us." And the other thing that was raised was statistical inequality, which Simon was just referring to, I guess, in those social areas. So disproportionately poorer outcomes in health, housing, education, and so on. And this is another quote from someone, a Dubbo resident during the Freedom Ride, who said, "Yes, we've got freedom. We're allowed to go wherever we want. We can walk into the RSL. But alongside this, you have these high rates of unemployment, substance abuse issues, poor educational outcomes, and so on." And the other thing, I'm just trying to move the gallery view, and I'm accidentally touching the slides. The other thing that came up was that racism was always connected to First Nations people's status as colonised people. So this is also how it differs from racism that impacts on migrant groups. This is a quote from a man in Brisbane, two men in Brisbane actually, who were saying, look, you can see this unbroken line between past and present colonial policies, including in relation to child protection. The other thing they're saying is, though, that society as a whole and government in particular will not acknowledge that connection. So they don't speak about that past racism, about colonisation and policies as racism. You've got denial of Indigenous rights to culture and self-determination identified as racism by First Nations peoples. And they also were saying that basically all of this racism was in a way dehumanising Indigenous people as a way of justifying the taking of their land. So this is how racism differs for Indigenous people. So look, then I took all of that and I thought, well, does this mean the race discrimination legislation that we have in place is really not done much for Indigenous people at all, particularly in terms of increasing levels of racial equality? Obviously, we can't pin all of this on failure of race discrimination legislation, but if you look at what the law held itself out as being able to achieve, Gaze has suggested there's two primary goals, and just focusing on the first one, the legislation was intended to eliminate as far as possible discrimination against persons on the basis of race. And we've also seen there's some clear intention that it would provide benefit to Indigenous people specifically. This is quite clear in the speeches surrounding introduction of the legislation. It will not be able to achieve this if Indigenous people are not able to use the legislation at all or to positive effect. And so this brings up questions of access to justice. Access to justice is designed to do just that, to enable people to access legal processes and outcomes in an effective way. So it's a framework that looks for barriers that might hinder that access and tries to address them. That might be barriers that sit in law, in justice processes, or in justice outcomes. And the idea is to ensure equal access to effective processes and outcomes by addressing those barriers. I've spent some time looking at what the particular barriers to accessing justice in this area are for First Nations people. And what we see is that, in effect, law does become part of the problem, not the solution, as activists identified in the mid-20th century, because it's institutionally racist or, in effect, useless for Indigenous people. So I actually spent quite a bit of time looking at complaint statistics in the thesis. I've just pulled out some more recent data that's not as comprehensive, but what you can see here is that First Nations people are just not using the law to the extent that you'd expect, given the extent of racism and discrimination that they're experiencing. Just in 2015 and 16, you've got 152 and 211 complaints per annum. I just picked out one of the surveys. There's quite a bit of material on this, on the extent to which discrimination is experienced. This is the Reconciliation Barometer, which is regularly updated. 46% of all First Nations respondents identified experiencing discrimination. So if you think about 46% of our total population, which is well over 500,000 in terms of First Nations population, you'd expect a higher number of complaints. And this is without even thinking about institutional levels of racism, which affect many more First Nations peoples. Not all of that can fit within the provisions of the legislation, but some of it probably could. So in terms of why the legislation isn't working, you've got really a system that's set up based on formal equality. So in theory, everyone has equal access to initiation of a complaint through the complaints mechanism. But what that requires is that you're sufficiently informed, motivated, empowered, resourced to use the machinery that is provided to you. And what you see is that it's just not that simple for First Nations people. There's multiple barriers that they experience in the same way as other groups, but they also experience different types of barriers. And I've just pulled out some of the material that I gathered on this. The overwhelmingly biggest, most significant barrier is that people just do not know that this law exists and or how to use it, but particularly that it doesn't exist. We found this the first time around with the Indigenous Legal Needs Project, and it was really obvious this time around. Partly that might be to do with language issues, literacy issues, levels of education and so on, but also they're just so used to seeing the law as a criminal justice mechanism. They wouldn't think, you know, many civil law issues are just not on their radar. And the other thing that came up is because of the high levels of racism they've experienced, there's really high levels of resignation towards the issue of discrimination, people feeling really disempowered and they don't trust anything to do with government. So there's just a few quotes here that represent that. People just can't be bothered, they don't care. There's just so many issues of racism, which one do you pick? And then the second quote is, you know, speaking to this process of disempowerment, Aboriginal people are not sufficiently empowered to assert their rights in this area. And the third one is just saying, look, I wouldn't go anywhere near any sort of legal processes. I'd rather go to a coffee shop and someone say sorry to me there. There's just no trust in the legal system at all. This last one is just saying, look, it's just doesn't fit with First Nations culture. What I meant to say at the outset here, sorry, is that this is actually in relation to people having to initiate a complaint on their own. So that's how the system works. Individuals have to be able to stand up and complain. And what this quote here is saying is, look, we don't necessarily work that way in the community I'm in. We think about our rights collectively and about communal approaches. We don't want to stand up as individuals. The next bit is just saying, look, the definitions in the law don't match the experiences of discrimination that Indigenous people commonly experience. So there's a failure to respond to more systemic issues, which you see in the statistical inequality. So this quote from Morton Robinson is saying, you know, we find racism the law finds racism from time to time, usually with reference to the overt behaviour of individuals, but there's not findings of systemic racism. And the instance she cites is of an Aboriginal man that complains about not getting a job. The employer can say, look, he just didn't have sufficient levels of merit. What is left out of the equation is perhaps he's not at the same level as everyone else because of this ongoing racism that Aboriginal and Torres Strait Islander people have experienced over centuries. And the other part of this is that there isn't any recognition of the denial of Indigenous specific rights as discrimination. So there's a number of cases I could have cited on this, but the case, it's quite old now, but it's quite a good case to make this point, the Traeger Park case. In this instance, an NT minister had closed down a school that was working really effectively with Aboriginal kids because it recognised in part because it recognised their rights to culture. And the families complained about this and said, no, we want our kids to go to that school. What was found in that instance is that there wasn't any discrimination, direct or indirect, because the kids still had access to education. They could go to a different school. It wouldn't be a school that would recognise their cultural rights, but it wasn't actually unequal treatment. And so that denied their right to culture, but also to self-determination, because these Aboriginal families wanted to be able to make a choice about where their kids went to school. So I'm just going to move on to solutions now with a few slides. What we need to do is rethink this idea of access to justice for First Nations peoples in the area of race discrimination. You'd think, I suppose, that given all the problems, maybe we just throw the law out altogether. I spoke to participants about that, and really they were pretty keen to keep it. They liked the concept. They thought it was really important. We saw that when government tried to water down Section 18C of the Race Discrimination Act. There were quite a number of Indigenous organisations that came forward and said, no, we really need to keep this legislation. It's really important. Obviously people need to use it, however, need to be able to use it. So what we need to do is to adapt legal responses so they better respond to this difference in terms of First Nations perspectives and needs. And this is actually substantive equality in terms of how the legislation would work. I've just provided one quote here from Hannah McGlade, who says, look, you know, Indigenous people do have a right to access justice in this area. Aboriginal people know that Australia is a racist country. We have a right to legal mechanisms in order to access effective redress. The other thing that I'd say though, and that I found in the work that I did, was that we do also need to think outside. So that's one way to expand our concept of access to justice, bringing Indigenous perspectives into it. We also need to think about access to justice as not just about law. It's really squarely sitting in the law at the moment. It's about legal processes, legal outcomes, legal institutions. There's been a bit of a push for thinking about things like law reform, which is still law, but also policy reform, building civic respect for rights, and also these sorts of social movements that we talked about at the outset. We can't rely on the law as being the complete solution. And what this also allows us to do is to bring in these Indigenous-led direct action events and activities that may also that are also effective ways for Indigenous people to seek justice. There's a couple of quotes here from participants who just said, look, I wouldn't have a bar of the legislation. I'd still prefer to march in the streets. And so maybe we include that in how we frame access to justice. One guy in Cairns said, you know, is it important to have laws? To a degree, yes, but it's still happening. So what's the point? They haven't actually done what they might have done. The law was just there to kind of keep everyone quiet. And the second quote is from a woman in Melbourne who was just saying, you know, where has all that activism gone now? Did it all just kind of get sucked up into the legislation? In terms of Indigenous people having a right to access to justice, this is actually enshrined in Article 40 of the United Nations Declaration on the Rights of Indigenous People. What you can see here is that it's combining access to justice, sorry, it's framing access to justice as a human right, which it is a human right, but it's also a way of, I guess, realising all other rights, including Indigenous rights. And the provision also really what it does is make the two rights indivisible. So human rights, including a right to access justice or a right to racial equality, need to always be interpreted for First Nations peoples in ways that uphold and respect Indigenous rights and principles. So rather than being separated, as we said at the outset, they really sit together. And so what I looked at was some of the key United Nations, the Declaration principles that could be used to make adaptations to the way the law was working. These are non-discrimination, self-determination, recognition of culture, and participation in decision-making. A few suggestions were made about, I don't think you can see that last one, but I'll read that out, about how we adapt the legal responses. So there's already been some movement to do that in the criminal justice system. We've got Murray Courts, Murray Courts, circle sentencing and so on. Maybe we need to adapt some of that in the civil law system. There was discussion of increased Indigenous input into and leadership within the complaints process. So setting up, you know, First Nations consultation or advisory groups and having First Nation co-commissioners. Introduction of cultural impact statements to reform existing race discrimination law and other law and to inform jurisprudence in this area, and also increase capacity for anti-discrimination agencies to take more action rather than relying on individuals to come forward. And this is just my last slide saying, look, do we also include in access to justice these other strategies that the people I spoke to, Indigenous people I spoke to, spoke about as ways to deliver justice? So one part of it was increasing or building on empowerment in Indigenous communities. What this would mean is that they might be able to take direct action when they're discriminated against or encounter racism, with or without referencing legal rights, but it also might mean that they're more likely to access the legal mechanisms. So a couple of things suggested was, you know, really making sure that community holds and shares the knowledge about rights in this area. This could be things like, you know, Aboriginal health services playing a much greater role in a justice sense in informing people about their rights, or it could be just about community advocates holding and sharing that knowledge within their own communities. And then people talked about collective calling out of racism outside of the legal system altogether. So there was a really great example of this when Bill Leake put out a cartoon about an Aboriginal father drinking and really neglecting his child. It was fantastic to see Facebook get flooded with all these images. Aboriginal fathers posted of themselves and their kids in a much more positive light. We also need to change the way community understands these issues, so they have to have greater awareness of responsibilities under the legislation, greater awareness of Indigenous culture, and of racism against Indigenous people. And the last one was just about changing the way government's working. Government needs to be addressing its own racism through policy reform. So rather than an individual complaining about racism within the housing system, maybe government needs to turn around and change the way that system is set up. And then there was also discussion of changing the relationship between Indigenous communities and government. And one way to do this is through Aboriginal justice agreements, which some of the jurisdictions have set up, which is a partnership. It sets up a partnership in the way that government and community resolve justice issues. So I'm going to finish up now, stop sharing, and I'm going to hand back to you, Simon.
Thank you very much, Fiona. I'm looking forward to a discussion. I just made a note of something that jumped out at me early on in the presentation. It's not a happy quote. law is part of the problem, institutionally racist, useless. So perhaps not the most upbeat note on which to introduce you, Paul, but and to be fair, Fiona, you finished with some strong ideas of what alternatives might be. Anyway, I look forward to coming back to that. And everybody, it gives me great pleasure to welcome Dr. Paul Gray. Paul is a Wiradjuri man who completed his PhD in experimental psychology at Oxford, where he was one of the inaugural Charlie Perkins Scholars. Paul's an associate professor at the Njabmana Institute for Indigenous Education and Research at UTS, which is where Fiona is as well. Among his many roles as a psychologist and in public policy, Paul was the executive leader of strategy, policy and evidence at ABSEC, the New South Wales Child, Family and Community Peak Aboriginal Organisation, the peak body in Aboriginal child protection in New South Wales. And in that role, Paul led the development of community-led approaches to child and family wellbeing and advocated for systemic and practice reforms grounded in the rights and interests of Aboriginal children and families. Paul, over to you.
Thanks, Simon. Yiradu Marang, Yuandu Paul Gray, Baladu Wiradjuri Gabir. Good morning, everyone. My name is Paul Gray, and I'm a Wiradjuri man. Ngadu Banagu Galbara Tarawal Main Galang, Gangu Ngurambanga, Ninangan Giri Duran Yagai, Mangangau. I'd like to acknowledge the traditional owners on whose land we're meeting today. I'm participating from Tarawal country, and I want to pay my respects to their elders past and present. I also want to acknowledge those still finding their way home, back to family, to community and to country where they belong. Thank you for the invitation to contribute to this conversation, and thanks to Fiona for setting the scene and for honouring that history of activism and advocacy over a long period of time. Thanks too for sharing your insights regarding Sorry, I have an error coming up. Can everyone hear me?
Yes, we can hear you.
Yeah.
Okay, thank you. And thanks, Fiona, for sharing your insights regarding access to justice for First Nations peoples. I hope that my remarks will touch on some of the issues that you raised, looking particularly at the ongoing intervention of the state in the lives of Aboriginal children and families. I also want to acknowledge my colleague, Kerry Liebsman, who I've been working with on some of these issues, including for an upcoming paper of the Indigenous Law Bulletin that forms some of the basis for this talk. So in a recent article by two leaders of the US Children's Bureau, David Kelly and Jerry Milner, they observed the way that child welfare laws, including those promoting separation and adoption, and more recently that place time limits on families to address risk concerns and achieve the restoration of their children, versions of which were only recently introduced in New South Wales, disproportionately affect poor families and families of colour. This, they argue, should give us pause. During this time of reckoning, they write, veils are being lifted and society is becoming increasingly aware of barriers to equity and the impact of laws that may appear neutral on their surface, but cause harmful consequences. Child welfare legislation should not escape scrutiny. While Kelly and Milner are talking about the United States, they could equally be talking about the child protection system here in Australia. According to the Australian Institute of Health and Wellbeing, the Child Protection Australia report, in 2018-19, 1/3 of all children who are subject of a substantiated risk of harm came from the most socioeconomically disadvantaged segment of our society. Kelly and Milner note how this inequality reflects a dated philosophy that sees parents facing poverty as inherently flawed, their children in need of rescue through removal and adoption. They continue, the ability of government to end a family is a profound power, rivaled only perhaps by life imprisonment or the death penalty. We must treat it that seriously. The fact that it is overwhelmingly poor families that we end should greatly startle our collective conscience. It is a fundamental feature of the rule of law that powers exercised by government be accountable, that there is trust between those who exercise power and those who are subject to it. And yet, despite the significant power entrusted to child protection authorities, there is very little transparency or accountability. This was a key finding of the recent Families Culture Review of Aboriginal children in out-of-home care, that there are limited effective oversight or accountability of the department or its officers who wield this extraordinary power. Those that do exist are either limited in scope, such as through the Ombudsman's or the Children's Guardian, or dependent on the information provided to them by the department, for example, in the case of the Children's Court. The review reported instances of the department providing misleading evidence to the court, an issue compounded by poor access to advocacy and legal representation for many families. Other reforms have further chipped away at accountability and transparency, such as the shift towards permanent care orders, which redefine out-of-home care, and remove key safeguards, such as ongoing monitoring of placements. There is little public reporting about outcomes for children and families, while other provisions discourage parents from speaking out. So families experiencing poverty in particular are subjected to the extraordinary intervention of the state with little effective recourse or accountability. And Aboriginal families are disproportionately within this segment of our community. But the disproportionate intervention of child protection systems in Aboriginal families is not only a result of this socioeconomic disparity. There is also, I think, a direct element. The operation of the child protection system itself includes an inherent cultural bias. Last year, 40% of all children in out-of-home care were Aboriginal and Torres Strait Islander children. Aboriginal and Torres Strait Islander children were 5 times more likely to be subject to a notification, 6 times more likely to be the subject of a substantiation, but 10 times more likely to be in out-of-home care than non-Indigenous children. While these figures, I think, demonstrate that initial disparity at the point of entry, they also suggest that this is then compounded by the operation of the child protection system itself, which is less capable of responding effectively to Aboriginal families and preventing their escalation to more intrusive interventions, including the forced removal of our children. This disparity is, I believe, the responsibility of successive governments who have established and maintained child protection systems that routinely fail Aboriginal children and families. This includes the use of inappropriate assessment tools, the exercise of discretion and judgment of Aboriginal families, often by non-Aboriginal experts, and the imposition of ill-suited models of family support, often imported from overseas, without consultation with communities and lacking any evidence of their effectiveness with Aboriginal families, rather than investing in Aboriginal communities to develop culturally embedded, place-based approaches. All of these contribute to the increased likelihood of Aboriginal families escalating through the system and ultimately poorer outcomes for our children, poorer well-being outcomes, poorer education and employment outcomes, and significantly increased likelihood of entering incarceration and justice systems. For Aboriginal people, though, the relationship between colonial governments and our children has always been like this. Nakata and others argue that this is a core part of settler colonial logic. To realise a non-Indigenous nation and secure its future on Indigenous land requires the disappearance of those whose very existence undermines the false settlement narrative. While our contemporary frameworks may be superficially more neutral, they remain the descendants and heirs of earlier assimilationist era policies aimed to absorb and ultimately disappear Aboriginal futures. And they perpetuate disparities and biases that further entrench their disproportionate intervention in Aboriginal families. But it doesn't have to be this way. The Families Culture Report identified 2 key areas of reform that, if adequately implemented, would significantly contribute to addressing this overrepresentation: greater recognition of the principle of self-determination and strengthened mechanisms for transparency and public accountability. That is, Aboriginal peoples and communities should have control over our own lives and collectively determine the systems and supports to secure the future well-being of our children, our families, and our communities. And systems that wield such extraordinary power should be transparent and should be accountable to Aboriginal communities, including through an independent and empowered commission. Unfortunately, the government's response has done little to address these foundations. The review made further recommendations to address the overrepresentation of Aboriginal children in out-of-home care, including legislative changes, proportionate investment in Aboriginal community-led prevention, family preservation and restoration supports, and increasing access to advocacy and legal support for Aboriginal people. Again, there has been little commitment or additional investment from government to fully implement these recommendations. Rather, I think what we saw was a response that sought to dodge these key issues and to frankly make very few changes at all. What I will point out is that these systems and the inequalities that they entrench operate in our name. As Kelly and Milner wrote, noted, the social inequalities that drive intervention by the system and the racialized way that this operates should startle our conscience. That our contemporary systems have never addressed the direct inequalities inflicted on Aboriginal and Torres Strait Islander communities should further embarrass us. It should embarrass us not because these systems are flawed or broken, but because they aren't. These systems work, they achieve what they were designed to do. Our system is built on a philosophy that transfers children to more suitable families, a philosophy that has always had socioeconomic and racial undertones. That less than 15% of the child protection budget is invested in family supports, and very little of this is directed to Aboriginal communities for community-led solutions, I think supports this point. We should be embarrassed because we allow these systems to perpetuate these social harms in our name. If we want these systems to achieve different outcomes, we have to redesign them with new outcomes and values in mind, including social justice and sustainability. Part of our custodianship in this country means taking care of all who walk on it. The program provided by Davis in the Families Culture Review will improve the child protection system for all children and families, but particularly Aboriginal children, who currently are amongst those most harmed. The issue of accountability is for all children who may find themselves caught in the statutory child protection system, as is the need for greater focus on family supports and access to advocacy. For Aboriginal children, the colonialism in the DNA of these systems and the harms that they continue to inflict on my community can only be addressed by finally respecting our right to self-determination, allowing us to redesign and reclaim systems that promote the safety, welfare and well-being of Aboriginal children and families. If we want to see more just and more equitable approaches that honour Aboriginal perspectives and aspirations, we have to create the space for them. Families culture, I believe, gives us such an opportunity, and one that I hope will not be squandered. And that's all I have to say. Thank you.
Paul, thank you very much. Just while I'm formulating a question, I don't know if you're able to do anything just to check on the sound quality coming through from
Yeah, I'm working on it.
Okay, thank you. But in fact, the first thing, the question that has come in that I want to put back to you, I heard in what you were saying real resonance with Fiona's point about just how inadequate law is, inappropriate for white man's law for Indigenous people. So the first question we have here seems to bring Fiona's thesis into your experience. And I'll just put the question to you: is law the right avenue? Now, in saying law, I think we're saying, is white man's law the right approach? Is there another way? Fiona was talking about other ways of racial equality, but I'm coming to you, Paul. Are there other ways of dealing with issues of child welfare, Indigenous child welfare, than the system we have?
Sorry, I'm just trying to literally kill everything that my computer is currently running to try to free up as much bandwidth and resources for my audio.
That's good.
I do apologize. Look, are there other ways? Of course there are. And I think, you know, part of the work that we've been looking at, indeed, has been sort of exploring some of the opportunities in other jurisdictions, you know, and particularly internationally. I think, though, at the heart of it, I think, is some of those things that Fiona mentioned around fundamentally changing the relationship between Aboriginal communities and government, and that has to be at the heart of it. So unless we actually address some of those things, our other initiatives are likely to be limited. But for example, the Americans have had something called the Indian Child Welfare Act for, I think, more than 40 years. And one of the things that act does, among a whole range of other things, is requires states to approach the child's tribe and offer them jurisdiction of child protection matters. So when a child, no matter where that child is or where they come to the attention of a state, if that's a child that's eligible for membership of a tribal nation, then the statutory child welfare system is supposed to contact that tribe and say, hey, we've got concerns about one of your kids. How would you like to proceed on this? And I think things like that can emerge. And obviously the other side of that is that if you're going to have an approach like that, then you need to functionally support, you know, Aboriginal nations to develop their own systems and approaches to do this. And certainly that's part of the work that we've been working on designing. It's tricky work. And I think, as I say, it really requires a shift in the relationship between government and Aboriginal communities, because I do think that fundamentally we still have a view that that the issue of Aboriginal peoples is something that government has to solve, instead of recognising that we're quite capable of determining our own futures.
That would seem to be the fundamental equality proposition, isn't it? Indigenous people have the right to be making laws about their own future. Self-determination would be equality. Fiona?
Yeah, absolutely. Paula, do you think the reforms that have been introduced in Victoria, which kind of does pass that jurisdiction back to an extent, have you got any comments on, or could you explain a little bit about that? If you, I'm sure you know a bit about that, how it's working.
Yeah, like the delegated authority pieces. And look, I think they're a step in the direction. But I think too, like, and we've seen similar steps in other jurisdictions as well, in Canada and whatnot. But I think it's an important step, and perhaps will, and I hope, contribute to further building those systems. And I know Victoria has got some great community organisations like NACA and others that have been doing this work for a long time and are really well established. And so, hopefully it'll contribute to that. But in a way, it still frames it within a broader system overseen by the minister and the state. So it's not truly an Aboriginal-led system in a way.
Sure.
But it's certainly a step in that direction. And look, I'm in favour of both incremental and radical change. I'll take either, so long as we're moving forward.
Yeah, but don't you think too, Paul, like I think the thing that strikes me about the law is it's really a response to pointy end problems. Yeah. So for me, this, community development approaches always have to be the first port of call, whether you frame them as access to justice or justice strategies, I don't know. In a way they are, because they're passing back those core principles of self-determination and protection of culture and all of those things. But in both racism, both in terms of racism and child protection issues, like I think it's about strengthening community and working outside of the law. I still think though these legal systems need to work a lot better, because people, as we said, as I was saying, they need to have the right to access those remedies, but they are, you know, First Nations people are going to be pulled into that child protection system. So that's why you kind of need those two approaches, that community development approach and reform of how the legal systems are working.
And I think there are legislative I think we could craft legislative frameworks that create space for both of those things and actually require
yes,
support for those. Because unless we create that space, then I think we're going to kind of see the dominant approach continue to be the dominant approach.
But Paul, when you say we could draft the laws, who's going to be drafting those laws?
Well, and look, and I think this is what I mean by, you know, whenever we have relationships between states, then it's on those states and their governance mechanisms to work out the implementation of those agreements, right? Whether we're talking about trade deals or whatever it is. And so, look, I think first comes the relationship part and working out what those, what that enabling framework should look like. But then it comes down to actually negotiating that out. And we've got, certainly Aboriginal communities have significant legal expertise that can facilitate, you know, in Western legal systems, who can facilitate that process. And who can also, you know, do the work of, I suppose, codifying, if communities want to, what community approaches would look like. I'm not saying that they have to, but that would be a matter for communities, but certainly we have the expertise for, you know, Aboriginal communities have the expertise for that as well. As I say, it's about creating the space, I think, first and foremost.
But also, like, it just feels like, you know, First Nations people have been putting forward the solutions, including in terms of legislative reform. I mean, how many countless inquiries have there been and so on, but it's just not, it doesn't seem to hit the ground. Okay, so that's, I don't know. I think that's also one of the things that came out in my thesis is really putting First Nations power in Parliament and in those decision-making positions, so you can kind of actually bring about some change, hey?
Well, and I think there's a reason why a lot of the focus has been on things like the Uluru Statement, like the National Agreement and the priority reforms that are within the National Agreement, because it, you know, it very much is. We have seen a cycle of, and child protection is a key part, you know, a key example of this. We've seen a cycle of reviews and reforms over the last 20 plus years that have all recommended the same thing. That Family is Culture recommended like 12 months ago. And so it's not a failure. It's not the fact that we don't know how to address these issues. Apparently we just don't want to. And so I think that's, you know, that's where that relationship needs to change.
Well, I ask both of you, in one of the questions from the audience refers to the Olabud through practice in Halls Creek, which I learned about at a public policy forum last night. And it's underpinned, as Fiona, your work in justice reinvestment is, in community-driven community consultation. And the examples around Australia when this happens are stunning, the transformative power of community engagement and consultation. But the simple question is, what needs to be done to make that happen? How do we transform Indigenous public policy to a consultative, Indigenous-driven process?
Yeah, I think justice reinvestment is a really good thing to talk about, because what that does is probably a lot of people attending know, it really, it pivots around improving justice-related outcomes. So, and it's had a particular focus on pulling young people out of the prison system, but it can focus on any age group. It's a US concept that didn't have such a focus in First Nations communities over there, but it really has here been really focused on First Nations communities. In looking at how we change those pointy injustice outcomes, it seeks to re-empower community to think through what are the drivers of entry into that justice system. And in doing that, it might be looking at reforming the justice system, but importantly, it looks at what's happening at a ground level around a whole range of social issues. So it does start to do things like potentially support families that are struggling, keeping kids out of the child protection system, looking at educational outcomes, looking at health outcomes. It kind of sees that holistic picture.
So from your position there, how do you see yourself entrenching that? How do you mainstream that approach in Indigenous issues?
I'm not sure about mainstream. Well, you mean in terms of how you'd roll it out more generally? Yeah. Well, there has been a bit of a push. There has been a big push in the Australian Law Reform Commission report advocated for, that was looking at Indigenous incarceration, advocated for JR and setting up a national body that would push this thing onto the national platform. Look, there's so much to say about justice reinvestment, but I think the other thing is it also has to come from the ground up. So the more communities know about it, the more they will hopefully demand it. And you kind of get that groundswell rather than just a top-down approach. But it's really a fantastic way of working and racism. It can address issues of racism either directly by, people knowing more about their rights. That might be something the community calls for, but also looking at the way these institutions are working in a racist way and addressing that. So yeah, it's really good.
And I think the principles that underlie those approaches, Fiona, are about place-based, about negotiating with community, and really sitting down with community to understand not just the problems as they see them, but also then what the solutions are to those problems. It's the process that matters, as opposed to the solutions themselves. So it's not about, deciding that a particular intervention that community X used over here delivered really good outcomes on a particular issue that they were facing, and here's a community down the street that has the same issue. We'll just, we'll do the same night patrols or whatever it is. That's not, that's what we have tended to see in some of the solutions. Oh, night patrols worked, so we'll roll night patrols out everywhere. And I'm not having a go at night patrols. That was just the thing that came into my head. But it's about the process of actually how you sit down with community and decide what is the priority, what is the key issue facing your communities at the moment, and what do you see, what do you want to try as the solutions, and allowing that to move forward. And I think in terms of how you enable that, I think that's what, in my view and my reading of things like the Uluru Statement, and as I said, in the priority reforms in the National Agreement, it's that sort of local engagement that they're trying to generate, so that local communities are able to actually control the commissioning of services in their community and how they should be oriented. But also, if we're taking a commissioning approach, it's about communities deciding the outcomes that are to be achieved as well. Because as that great quote, Fiona, I think it was, I don't recall and I don't want to misattribute it, but one of the great quotes on yours was about recognising that what's good for non-Indigenous people may not be seen, what Aboriginal people feel is good for themselves. So it's about understanding that we have a different idea of what outcomes are, and what our what are the sorts of things we want to see for what we mean by well-being, and what we want to see for our communities and the members of our communities, and allowing us to orient a service system towards those.
Yeah.
We're running happily late because there's so much good stuff to talk about. Can I finish with this one question, which is in a way to reassert the conventional, only because that's what we're trying to depart from. What place then, in light of what you've both said, what place is there for conventional positive law, for these crude frameworks of, the RDA, of child welfare legislation and so on? You're talking about process, you're talking about really sorting stuff out on the ground. How much regard do we need to have to the formal legislative frameworks?
Well, I definitely think we need to retain them but reform them. I mean, I'll just go back to that point I made, is that yes, there are some, and I'm saying that because of what I learned through talking to people in communities, but there is criticisms and there are still people that say just chuck the whole thing out. But it seems to me that there is a place for them. Aboriginal and Torres Strait Islander people I spoke to did think the concept was important. It's really just trying to make it more instrumentally valuable.
Okay, thank you. Oh. And Paul?
Well, I think it's the tool we have, right?
Hmm.
And so there's still very much a need, and I think this is where sort of Fiona's work looking at improving access and the alignment of those tools so that they better meet the needs of communities is really important. I mean, I think we can walk and chew gum at the same time. I think we can fix up those systems and provide better safeguards for communities now using the systems, using the tools that we have, whilst we do that sort of larger process work of thinking about how they might be reimagined to do better.
Thank you both for a really rich discussion. I'm sorry we're squeezing such a massive issue into a short space of time, but I think you've stimulated a lot of people. And to indicate that, can I say to the audience, I'm going to invite Fiona and Paul, if they can, to answer some of your questions, Q&A directly. They can respond during the morning because we don't have time to go through the questions. Fiona has agreed to share her slides, so we'll arrange to post the slides to the chat. And I'll talk to Paul about what access people might have to your presentation, Paul, because people are really keen to have a record of that. Thank you all. We're going to take a short break and I don't have control over it, but a slide will come up telling you that we're going to have a short break. Can you come back at 10:30, same time, same place, just switch yourself off and come back and we'll resume with a disability discussion. Oh, I actually wrapped things up early. I pushed us too fast. I was 15 minutes ahead of myself. Don't go away. Are you two ready to keep going for 5 more minutes?
I was thinking you were a bit early there.
Sorry, I'm doing this in my head and I was in full-on chair mode. I'm really sorry for everyone. That's good. We have more time and I'm really sorry to have pressed it. Let's come back then, Fiona, to, let's try and finish at 10:30 as planned. Fiona, the Justice Reinvestment Solutions, one of the questions is whether, I'll read the question, can a Justice Reinvestment Solution through local community activity be implemented usefully in the NT to address child incarceration? I think 100% of juvenile detainees in the Northern Territory are Indigenous.
So there has been justice. So there are now justice reinvestment communities in WA. One of them was referenced here. Catherine has been working with justice reinvestment. There's one down in South Australia. Cherbourg is doing justice reinvestment, and I'm now working in Moree and Mount Druitt, but there's also been justice reinvestment in Burke in New South Wales. ACT has a whole of government approach, so they're doing it. So you can see it's kind of everywhere, a lot of different places, and it has been in the NT. One of the interesting things in the NT, as an example, is the DSS has introduced this initiative, Stronger People, Stronger Places, or it might be the other way around. And this is this place-based approach that Paul's been talking about. So Tennant Creek is one of their 10 focus sites, and they have already set up this collective impact structure, which is designed to bring everybody, community and services together to try to respond to community priorities. 3 different tiers of government in there. They don't at this point have a focus on justice reinvestment, but it's hoped that what they're going to be trying to do is to address all of these underlying issues that can feed people into that system and into child protection system. And so it may not be called justice reinvestment, but I know they have some focused on justice outcomes. So there is some work already going on in the NT, and there have been a number of people advocating for it in the NT. I don't think it's got as high a profile as it could have. And you also don't want to push it on communities, because communities have to make the decision they'd like to work in that way. But having said that, it would be great to see it roll out in other places in the Territory.
Fiona, there's a question here which I think picks up on the work you did, the extensive field work you did around the RDA. But it's a broader question about law reform generally, because we have established law reform consultative processes on a whole range of things. What's the major barrier to seeing strong Indigenous community consultation in law reform? How can Aboriginal people equally participate in the...
Look, I think we're just talking about this, hey, Paul, that I think they are trying to, and they are contributing, and they But, you know, they also get very sick of being asked the same questions with absolutely zero results. So as I think I was saying before, I think it really is about empowering Aboriginal people to participate at all levels. I really love community level participation because these are people that are on the ground experiencing these issues. But I think it is about ensuring that First Nations peoples are in those decision-making roles. The other thing is setting up structures, representative structures that enable people to come together and speak collectively about the issues. So I said something before about Aboriginal justice agreements. Post the Royal Commission, each of the jurisdictions were supposed to be setting up these justice agreements to reduce incarceration and therefore deaths in custody. And it hasn't really happened to a great extent, but in Victoria, which has had the most successful, most effective justice agreement, they do have an Aboriginal Justice Caucus and so on at local, regional and jurisdictional levels that can kind of come together and think about these issues as a collective. So I think having those structures, having formal agreements, ensuring First Nations people have more political power. Paul might have a comment on that as well.
In your policy work, Paul, do you have a view on effective Indigenous consultation processes?
I think what I would say to that is that consultation has never been sufficient. And so I think that's and I was seeing that in some of the comments there, and you know, it certainly needs to happen. But I think what we often see is there's a difference between consultation and listening. And so we often see people talk to Aboriginal people and then decide, but the decisions are still made external to us. And so I think, you know, that's the sort of key point. In the child welfare space, I think that's particularly fraught. So I'm not, I don't know that there's a good example. One of the things that I was involved in was the development of the Aboriginal case management policy in New South Wales. And I think that was a relatively interesting approach, because what was initially, you know, was kind of initially set up as a consultative process, a partnership between the department and the Aboriginal Child and Family Peak, ABSEC, where I worked at that time. But then what we ended up trying to do is to say, look, well, how about you just commission us to create it, and we'll run off and do that. And so it meant that then the policy development was led by an Aboriginal organisation, a membership-based organisation that members come from Aboriginal community-controlled organisations and Aboriginal individuals. And so our accountability is back to community. You know, obviously I'm not trying to say that that's a perfect system, but I think those are some of the elements that work better, where it was, look, we need a policy that addresses this need. You guys go off and build it. And the policy ended up looking, I think, quite a bit different to what people expected. And it was different because it took a different process. It was commissioned and built with, you know, DCJ commissioned the Aboriginal community to, or a community organisation to try to put it together. And so, as I said, I think some of those processes work quite well.
Fiona, I'd like just to come back to the RDA and the hope that it promised. It would seem, as you started by making the point that it was there first and still there principally to address issues of formal inequality.
Mm-hmm.
But then you went on and illustrated the fact that Aboriginal and Torres Strait Islander people in Australia continue to suffer instances of formal inequality as well as more broadly.
Yeah.
So it would seem still to have some work to do there. And there are aspects of the RDA, really adventurous aspects, that haven't really been used in the legal sense, sections 9 and 10, you know, which might be used more extensively. So in a formal sense, I think of Paul's comment that, which was a pretty confronting one, Paul, when you said that the child welfare system in New South Wales you're dealing with affects Aboriginal people disproportionately, but you said it's also directly discriminatory. There's an inherent cultural bias in it. So if we're dealing with still at state institutional levels, questions of formal, structural questions of formal inequality, Does the RDA and equivalent state racial discrimination laws not have work to do still to address formal inequality?
Definitely formal. Yeah, absolutely. I mean, but I think I would really like to see it be used around these more substantive issues of inequality too. So I can see, in talking through civil and family law, civil law issues with Aboriginal and Torres Strait Islander people, a lot of it is actually about their interactions with government, with housing, with social security, obviously child protection, and so on. And you can kind of see the way those systems are working. You could potentially be putting in complaints about because they've got these requirements or conditions in order to interact with them or to get a certain outcome that potentially have disproportionately negative outcomes on First Nations people, but also potentially they're unreasonable. And so I think it'd be really great to see indirect discrimination provisions used to a lot greater, a lot higher level, because I think the direct discrimination stuff's really important to address, but I think if you can address some of that institutional stuff through the law, gosh, it'd be really good, because it would have a much broader impact. I mean, the thing with the complaints as they stand, when you do an individual complaint, what I saw is that a lot of the outcomes that people are achieving are financial compensation for that particular complainant. And potentially an apology. There's not a lot of structural change going on with those complaints, whereas with indirect discrimination complaints, you'd hope that you'd actually be changing things more structurally with those larger impacts, including in child protection spaces.
Okay.
That would be great.
I'm being reminded that having finished early, I'm now finishing late. So thank you both very much for your time. I really appreciate it. Fiona's slides are in the chat for people who would like them. And we'll now take a 15-minute break and come back to talk about disability.
Thank you.